What we're talking about today is estate planning 101. What that really means is we're talking about planning in the event of either death or the event of incapacity. And so we're going to talk about both of those different types of concerns that families have. Again, really, it's about making sure that you and your family are have a plan in place to make it as easy as possible in the event of a crisis. You know, it's hard enough when you have a family crisis, a health crisis, or a death in the family. It's hard enough. And so putting a few extra steps in place can really make it easier for everybody during those times. I'll tell a story several years ago when I first started practicing. I had a client who he drafted his own will. And sometimes drafting your own will is fine. Other times, there's just a little nuance to it that can create problems. So this particular gentleman drafted his own will, and he had 4 children, and he owned a ranch out in eastern Colorado. And as he drafted his will, at the beginning of it, he said, "Upon my death, I want my son to be my personal representative." Now, I should add that he had one son who lived on his ranch with him that was really running the ranch. And he had 3 other children that were all off doing their own things. And at the beginning of his will, he said that he wanted that son to be his personal representative, which is what we call the executor in Colorado. That's the person who's in charge. And then he said, upon his death, he wanted his son to divide up his estate and create one equal share for each of his brothers and sisters. You have to think about that for a minute. He said he wanted his son to divide up his estate and create one equal share for each of his brothers and sisters. Now, what he should have said was he wanted his son to divide up the estate and create one share for each of his 4 children. But instead, what he said was he wanted his son to divide up the estate and create one share for each of his brothers and sisters. So by accident, by wording, he left the son out. That's a big mistake. That's a huge mistake. And, you know, it's those kinds of mistakes that unfortunately I see that really just tear families apart. And while I will try to tell you some funny stories tonight, because I have to laugh because otherwise I'd be crying. While I'll try to tell you some funny stories, I would bet that everybody here has seen a situation, whether in their own family or heard of it from someone else, where somebody passes away and things go wrong and it tears the family apart and they never talk again. And that's not what we want. In the area of estate planning, we like to think of ourselves as being unusual attorneys. We want everybody to get along. We don't want people to be fighting. We want this to go as smoothly as possible. And so we want to look at documents, putting them in place in a way that will keep the families together and allow for transitions during those really difficult times. So what we're going to talk about today is I'm going to start by talking about documents that will help your family and you during incapacity and end of life. So we'll talk about financial and medical, and then we'll talk about wills and trusts, and we'll talk about how assets transfer in different ways. And then, as I said at the end, I'll stop and stick around for some extra questions. So let's talk about that incapacity part of estate planning first, okay? So if a person is incapacitated, meaning they're unable to manage their own affairs, it's important that they have documents in place that would allow for their loved ones to be able to step in and manage their assets. And the number one document that you need there is what's called a durable general power of attorney. Now, a durable general power of attorney is where you are appointing someone to make your financial decisions while you are alive but incapacitated. This is the person who would step in and pay your bills, file your taxes, fight with Comcast, deal with your real estate, manage your investments. It's all things financial. It's important to put that document in place when a person has capacity to be able to sign the document. You don't want to wait too long, right? And there's no reason to wait too long to sign it. Because when you put a power of attorney in place, you're not giving away your power. You're just saying that if you need assistance, this is who you would name to step in and help you. Okay. So that phrase that says durable power of attorney, what does that mean? Durability means that even if you become incapacitated, that your power of attorney is still in effect. That's really important because there's lots of different kinds of powers of attorney, and some powers of attorney aren't durable. They're designed only for a specific little thing. Like you could sign a power of attorney that says that if you were out of town, that this other person could sign on your behalf to sell your house or something like that. Or you might have a power of attorney that just allows somebody to deal with your bank account. A durable power of attorney says that a person can manage everything and they can continue to manage it even if if you don't have capacity. Some powers of attorney end when you don't have capacity. Well, that kind of defeats the point of what we're trying to accomplish here. We want to make sure that if you are incapacitated, that somebody else can step in and manage the assets for you. And it's important that you put that document in place because this is your opportunity to choose the person that you want to be in charge. You might have several different people in your life who could be in charge, but some of them might be better with money. Other people might be better with medical things. Some people might have very different viewpoints than you do. You want to choose the person that you want to be in charge. And on top of that, you also want to name a successor agent, right? So that if something happens to this person, there's already a backup in place, right? So I see a lot of clients who will sign a power of attorney and they might say, if they're incapacitated, they name their spouse to make their medical decisions or their financial decisions. But if they don't name a backup agent, then what happens is that let's say that I name my spouse as the agent under my power of attorney, and then he passes away and then I become incapacitated. I might have a power of attorney document, but there's nobody who's actually named to serve because I didn't name that backup agent. Okay. So it's really important to have that backup agent in place to say who would step in the event that first agent can't act. And I like to actually name a couple of them, right? Because that way your documents would stay in effect with you far into the future. We don't want you to have to be in a place where you're constantly redoing your documents. You want to think about, all right, the long haul. If this person can't act, it's this person. And if they can't do it, then it's this person, right? So that you have that plan in the future. Now, if a person doesn't have a power of attorney in place, what happens is that somebody has to go to court and do what's called conservatorship. Conservatorship is where the court appoints someone to manage financial decisions for somebody else if they're incapacitated. And you hear a lot of things about conservatorship in the news and in the media. For example, Britney Spears. Now, I never thought that Britney Spears would be teaching my clients about estate planning, but there you go, right? What happened with Britney Spears was that her dad said, she's not really capable of managing her own affairs anymore. And so he went to court and got appointed as her conservator, and that allowed him to take control of all of her assets. And there was a lot of hubbub in the news because everybody was saying, well, that's not fair. She should be able to manage her own affairs. And at the same time, he was paying himself quite a bit of money to manage her affairs. And it was a very expensive process and it limited her freedom. Conservatorships tend to be very expensive. And it's a full court proceeding where basically somebody's saying that you don't have the ability to manage your affairs. And that really does not feel good. I mean, I don't know about you, but I don't ever want to be in a position where somebody's hauling me into court and saying that I can't manage my affairs. So one of the reasons that you do the power of attorney is because if you have that in place, then nobody has to go to court and do the conservatorship, right? That's why you do it. Plus, that way you get to choose the person that would act instead of the court choosing the person who would act on your behalf. Now, when you sign a general power of attorney, it can become effective at different times based upon what you want for your life. So you could say that the power of attorney is effective immediately, meaning the second you sign it, your agent could get access to your bank accounts and they could mess around with your Comcast account and pay your bills and do with all of those things. Or you might say that you don't want the power of attorney to be in effect unless you are incapacitated, meaning that your agent would have to have a letter from your doctor stating that you're incapacitated before you can do anything. Okay. Or you could do a hybrid. You might say that it's effective immediately for your spouse, but for those successor agents, they have to have a letter from your doctor saying that you're incapacitated before they can do anything. Whether you want it effective immediately or a springing power just depends upon your situation. If you want it to be easy for your agent to get in there and take over your affairs if something happens, then you make it effective immediately. If it makes you feel better to have a little bit of a cushion and to have that person have to prove that you're incapacitated before they take over, then you make it a springing power of attorney. So they have to have that letter from a doctor first. Okay. But again, remember that with a power of attorney, you're not giving anything away. You're still in charge until you can't be. So a good example of this is my mom. When I first had my parents sign their estate planning documents when I started practicing law 25 years ago, my mom looked at me and said, well, if I sign this, does this mean that you're going to put me in a nursing home? Joking, right? But that's not what this is for, right? The power of attorney, you're still in charge. It just means that the other person can step in if you can't do it for yourself. Now, along with the power of attorney goes a HIPAA release. So HIPAA is that law that says that your medical information is all private, which is great in theory. When they passed this law, they were trying to do something good, but the effect of it has been really far-reaching. So what happens is that your medical information, which is everything from if you're even in the hospital, is private and cannot be released to anyone else unless they have a HIPAA release. If you've been to the doctor in the last 20 years, which I hope you have, you've probably signed a HIPAA release for your doctor. But that doesn't cover everything. That only covers that doctor's office. So as part of your estate planning documents, you should have a HIPAA release that would apply to everyone. And the purpose of the HIPAA release is so that then if, for example, I'm in the hospital, my agent can go to the hospital, hand them the HIPAA release and say, I need this information. You have to tell me if she's there. You have to give me her information, her file, tell me what's going on with her. Because without that, they don't have to tell you, right? And that's a critical part of being able to care for somebody else. It's one of those laws that it will sneak up on you. And a really good example of this is my parents. So my parents lived in a small town in South Dakota. And they volunteered at the hospital where I was born, by the way. They volunteered there for about 20 years after they retired. And one day, my dad, who had AFib, went to the hospital. And my mom called me on her cell phone and said, Beth, your dad's in the hospital. And I didn't pick it up. And so she left me a message. She said, I'll get back to you. And then she turned off her cell phone. Well, I couldn't get a hold of her. And I wanted to know what was going on. And I thought, aha, I'm smart. I'll just call the hospital. I was born there. They know who I am. They know who my parents are. So I called the hospital and I said, hi, is Ross Mitchell there? And they said, we can't tell you that information. And the second they said it, I thought, oh, I know that. I have to have a HIPAA release, right? But I wasn't thinking clearly because when it's your own family, you're never thinking clearly. And so I had to go find the HIPAA release, send it to them so that I could find out if he was even there, right? The HIPAA release is a very important, but usually overlooked part of your estate plan. So you want to make sure that you have that in place. All right, medical stuff. Your medical power of attorney. This is not rocket science. It's just like it sounds. This is where you're appointing someone to make your day-to-day medical decisions if you can't do it for yourself. It's generally not about end-of-life decisions. That's done in your living will, which is the next document we'll talk about. This is more about the person who would step in if you can't make decisions and talk to the doctor about what's going on and talk about your medication and set up your treatment plan and your physical therapy and get your lab results and all of those kinds of things. And again, this is where it becomes really important to pick the person that you want to make your medical decisions, right? Again, in families, I like to say we all have our own special gifts. Some people are really good with medical stuff. Other people are really bad with medical stuff. You want to pick the person who's better with medical things and who also might share your views about what you would want for treatment. Again, with the power of attorney, the medical power, you're going to want to make sure not only that you name your agent under the power of attorney, but also a successor agent so that if something happens to this person, there's a backup in place. And even better yet, another backup so that it's very clear who should step in and make your medical decisions if you can't do it for yourself. The third medical document is the living will. And that is the document where you are making end of life decisions. Okay. So the living will in Colorado, and I do want to say these documents are different state to state. Every state has different laws about end of life. And so in Colorado, what we look at is when you would want life support and artificial nourishment to be removed if you're in an end of life situation where you've been hooked up to a ventilator. Okay. So we look at two scenarios. First, do you have a terminal condition? Terminal in Colorado means that you have a condition that will cause the end of your life, and they can't fix it, and they can't cure it. Now, that's not enough. That's only one part. At the same time, you also have to be unable to receive or communicate information, which basically means that you're unconscious. And third, you're already on the ventilator, you're on life support, so you're not breathing on your own. And so if you are terminal and unconscious and on life support, the question to you is, how long do you want them to leave the life support on? In the grand scheme of things, what we're really talking about is they have the medical technology to keep you alive, to keep you breathing. How long do you want them to keep you breathing? If you're not really there anymore, right? Now, clearly, if they can treat you and you can get better, this isn't what we're talking about. This is truly a situation where there's nothing more that they can do. And they're keeping you alive by artificial means, and it's your right to be able to say how long you want them to keep you like that. The second scenario that we look at is what happens if you have a persistent vegetative state, which basically means that there's no brain activity. This isn't a coma, because in a coma, your brain is still going. You're still thinking. This is a point where there's no brain activity. Two doctors have said that you are unconscious. They don't think you'll ever wake up, and to the best of their knowledge, you can't think or feel anything. And so again, the question is, how long do they keep you hooked up to the machines that are just keeping you breathing? It's your opportunity to say that you want them to let you go. That it's okay, that they don't have to keep you alive forever, right? This is binding on medical facilities, and it's really a helpful thing to complete because it really tells your family what it is that you would want. And I always encourage people that even if you have a document like this, if you have a living will, you should still talk to your family about it because it makes a difference for them to actually hear you say what you would want. If you are then ever in this situation, your family can think back and remember that conversation and they can say, I remember Mom didn't want to be kept alive like this, and it will give them more peace of mind. It will also prevent arguments amongst them, at the hospital so that you don't have one family member saying, no, Mom wanted to be kept alive, and the other one saying she wouldn't want to live like this, right? If they can all remember that conversation, it's that much clearer for them. Again, estate planning is about preventing the arguments, right? Whatever you can do to prevent that. One note I will say here is that this is very different than a DNR, which stands for do not resuscitate. A do not resuscitate is a different thing that you would sign with your doctor. And a do not resuscitate says that if your heart stops beating, that you don't even want them to perform CPR on you. Now, typically people would fill in a DNR with their doctor if they have a terminal condition or if they're very elderly. right? But for most of us, we don't want a DNR quite yet because, for example, if I was down in the kitchen and bonked my head on the cabinet, I might be fine. If the paramedics show up and they perform CPR on me, I could be fine. I could live another, 40 years, right? But in some situations, you might not want them to do that. And that's when you do the DNR. The living will is there so that if they do perform CPR on you and then they do intubate you and you're at the hospital and then they say, didn't go well, right? There's no brain activity. Then you have the living will there to say, well, then let her go. Okay. So these documents all work together. Now, the other document that's really important is your disposition of last remains. And this is a document that allows you to say who would be in charge of your remains and also what you prefer, whether that is burial, cremation. There are also now lots of other green alternatives, natural burial, composting. There's also water cremation. So there's different options now, right? As opposed to just the traditional cremation and burial. And so it's helpful to tell your family what it is that you would want so that they don't have to try to figure it out. And again, we don't want them to fight about things. We don't want one of the family members to say, you would have wanted burial. And somebody else says, nope, you would have wanted cremation. This way it's clear, and it's also clear as to who's in charge, right? We don't want them to argue about it. So that's the incapacity side of estate planning. And, when I say the word estate planning, a lot of times people think, well, I don't have an estate. I'm not Bill Gates or Jeff Bezos, but we all have an estate. Your estate is just what you own, right? It's all of your stuff. It's your car, it's your bank account, all of those things. And so your estate plan is just planning for what happens in the event of death or incapacity. What we've been talking about so far is incapacity. So this way you get to say at incapacity who's in charge and what you want. And it avoids those things like guardianship and conservatorship. Again, conservatorship is where the court appoints somebody to make your financial decisions. Guardianship is where the court appoints somebody to make your medical decisions. And then the other part of estate planning is so that at your death, you get to say who's in charge, who inherits, and distribute your estate in the best way possible, right? The most efficient way possible so that people aren't fighting about it in court, which naturally tends to reduce the cost. So basic goals of estate planning are to distribute your estate to the people that you choose, right? Not to the people that you wouldn't want your estate to go to, but the people that you would want your estate to go to. Also, to lessen the expense. As I always tell people, it costs so much less to plan ahead than it does to clean up a mess later. This is your opportunity to plan ahead and say who you would want to inherit, to say who you would want to be in charge. Estate planning can also avoid or minimize estate taxes. Now, we're going to talk about estate taxes later. I'll tell you that it's less of a factor in this day and age than it has been in the past. But at any time that we can minimize taxes, we want to certainly look at doing that. Your will is also where you nominate someone to serve as a guardian for your minor children, right? So if you have minor children that you are in charge of, that's where you would say who you would want to take care of them if something should happen to you. And lastly, just like we've been talking about, to appoint the right people to make your medical and financial decisions if you become incapacitated. I see people at many different phases in their life. I have clients who are 21 years old who have inherited money because their parents have passed away. I have a client who is 105, right? And everywhere in between. And so there are different markers in life that motivate people to plan, where they realize that they need to do additional planning to take care of themselves and their loved ones. These are a couple of the major things. One is having minor children or grandchildren. So here's the thing. A minor child lacks legal capacity. You can't just leave money to a minor child. They lack the legal capacity to accept it. And so you want to leave money to a minor child in a trust for their benefit. Okay. That means that you have to set up either a will or a trust to say that at your death, anything that you would leave to that minor child is protected in a trust for them. And you name someone to be in charge of it and you give them the rules for what they can use that money for, right? That's how the correct way to leave money to a minor child. Also, to alleviate tax problems. As I said, estate taxes are certainly a concern for some people, and you want to minimize those taxes wherever possible. You also want to minimize capital gains taxes. And I'm going to kind of put that on hold until we're talking about joint tenancy in a few minutes, because I think it'll become more clear there. But certainly avoiding capital gains taxes, estate taxes, those are all concerns for people. Second, marriages or relationships and non-traditional families. This is a really big deal, and it becomes important for people to do planning in these relationships because marriage comes with rights, right? One of the many joys of being married is that you have rights to your spouse's assets and to be in charge of them. If you're not married, you don't have those rights. And so you want to plan appropriately for your significant other based upon whether you're married or not. Okay. When you are married to somebody, under the law, even if you don't have a will, they are entitled to a portion of your estate, or your estate will go to them, depending upon what your family looks like. And that can really create problems for people, especially if they have children from a previous marriage or relationship. So here's the thing. Under the law, if you don't have a will, there are laws called intestacy statutes. So it's like dying without a last will and testament, where the law says who would inherit if you don't do any planning. And under the law, it generally says that your assets would transfer first to your spouse if you have a spouse. If you don't have a spouse, then it would pass to your children. If you don't have any children, to your grandchildren. And it kind of goes through your family tree to say who would inherit the assets. Well, if you have a previous marriage or children from a previous marriage or relationship, that can really wreak havoc on that. Because here's what that would look like. Let's say that you have a married couple, right? And let's say that they both have children from a previous marriage or relationship. And let's say that they haven't done any planning and the husband passes away. Well, if he hasn't done any planning, under the intestacy statutes, everything goes to the surviving spouse. Now, his spouse owns everything, his assets, her assets, everything. And when that spouse dies, if they haven't done any planning, all of those assets go to her heirs. And his children over here got left out. That's not good. That's not what we want. So you do your planning because you're basically saying you don't want the statutes to control who inherit. You want to decide who would inherit. Okay. If I have a lot of couples, especially seniors, who are in relationships and they don't get married because they don't want that to happen to their kids. Well, now you also have a situation where you may want to be protecting your partner. Perhaps you live in the house that you own. If you were to die, does your partner become homeless because that home goes to your children? You can plan for that to say that your partner would have the ability to live in the house for a period of time. And then when your partner passes away or after a couple of years or whatever it is, then the house goes to your children. So everybody's situation is a little bit different in terms of what you're trying to plan for, right? And it's just about making sure that you have that written down and in place. It's also important to plan for potential disability. And unfortunately, I do end up seeing a lot of people who have been diagnosed with an illness, or they have a terminal illness, or they're very sick. And in those situations, having these documents in place, make sure that you have the right people to make your medical and financial decisions, but also that those assets would transfer to the people that you want upon death. Clients a lot of times also have disabled heirs. So maybe you have a child or a grandchild who is receiving benefits from Medicaid or SSI due to special needs, right? They're on the spectrum or there's a disability of some sort. And so in those situations, you have to be particularly careful because if you leave money outright to somebody who has special needs and they're receiving government benefits, even though your heart is in the right place, those programs require that those people don't have any money, basically. And so if you leave money to your child or grandchild to help them out, it will probably disqualify them from receiving their benefits. And that is a horrible thing to go through. When you do the right planning with somebody who has a loved one with special needs, you create what's called a special needs trust. And you leave the money to that person in trust so that it's protected for them. And that way they can still qualify for all those government programs to pay for all their care, but they have that additional money to pay for the extra things that they need. So that's an additional step that you want to take to put into place to make sure that those loved ones will be taken care of. And last but not least on the list, troublesome children, grandchildren, or heirs. And I'm sure it doesn't apply to anybody here, but sometimes I meet families who have children who they might not be great with money, or they are in a situation where they have tax liens or creditor issues, or maybe they're in a marriage that isn't very solid. These are all situations where you'd want to be careful about leaving money outright to someone, because if you leave it outright to them, they could either hurt themselves if there's substance abuse problems, or the money could be wasted if they're not good with money or it goes to pay their heirs. Or let's say that that marriage ends in divorce. If your loved one has inherited money and then they get divorced, there's the risk that their ex-spouse is now going to walk off with part of it, right? And that's not what you want. So those are all situations where, again, you can leave money in trust for those loved ones, protect it for them, protect against their creditors, against divorce, all of those types of issues. So those are some of the main reasons that people plan ahead and make sure that their documents are in place. Now, when you think about your estate, what really is your estate? Well, it's everything that you own. It's your house, it's your car, it's your investments, it's your large stacks of money that you leave laying around the house. It's also, though, your retirement accounts, your IRAs, your 401ks, your annuities, all of those types of accounts. And it's your tangible personal property. This would be things like your furniture, jewelry, family heirlooms, collectibles, and your life insurance, right? All of these things are part of your estate. Now, one of the mistakes that people make when they think about estate planning is they think that it's all about the documents that I draw up. And it's a good part of it. But as an estate planning attorney, I want to look at the entire estate and make sure that we're using all the tools at our disposal. And one of those big tools is a beneficiary designation. A beneficiary designation is a contract that you fill in that says upon your death who gets a particular account or life insurance policy. So for example, when you set up your IRA, right, you should have filled in a form with whoever holds that IRA. So if it's at Fidelity, you filled in the form at Fidelity, and you would have said, upon my death, this goes to, right, and you name the beneficiaries there. And whoever you name on that beneficiary designation form, that takes precedence over everything else. So even if in your will you said that you leave your IRA to me, your new best friend, Beth Mitchell, it doesn't matter. It matters what it says on that form. Okay, so you want to make sure that that's really well coordinated with the rest of your estate plan. Now, I will say, especially because I'm talking to on behalf of the church here, that naming charitable organizations on your retirement accounts is a great way to leave a gift to nonprofits. And that's because if you name a person as a beneficiary on your retirement account, when they receive that and they take money out of your account, they have to pay income tax on it. Just like you do. When you reach age 73, you have to start taking money out, right? And you pay income tax on it when you take that money out, unless it's a Roth, okay? When you leave it to somebody else and they take money out, they also pay income tax on it. But if you name a beneficiary as a nonprofit, they don't have to pay income tax on it. And so that's a really nice way to get more bang for your buck. You name the charitable organization as the beneficiary there on all or part of your plan, rather than saying it in your will, because in the will, right, they would pay, that would go through the estate process first, right? As if you name it of the beneficiary directly on the retirement account, goes directly to them and they don't have to pay income tax on it. Okay, so making sure that your beneficiary designations are coordinated with the rest of your estate plan, super important. And here's the other really big tool that we want to make sure we utilize, and that is joint tenancy. So when you own something in joint tenancy with somebody else, right, and you'll typically see this with spouses. So if you own something in joint tenancy and one spouse dies, their interest immediately transfers to that other joint owner. All that has to happen is you record a death certificate in the county, or you take the death certificate down to the bank and it just transfers like that. Okay, very easy, and that's why you typically see that. But where people make mistakes is a lot of times they will add their children onto the title of the house or their bank accounts or their investment accounts because they're thinking to themselves, I'm going to outsmart this system. I'm going to name the kids as joint owners, and that way it'll just transfer to them when I die, and they won't have to go through probate because it just immediately transfers. And that's very true. They will avoid probate, but what they're missing are the capital gains tax implications that can come from that. So I want to talk briefly about the way that capital gains tax works. So if on your house, right, if you live in your house 2 out of the last 5 years and you go to sell it, you have a $250,000 capital gains tax exemption. So you get free $250,000 worth of gain that you don't have to pay tax on, okay? If you keep your real estate until you die, you get what's called a step up in basis. So your basis is what you paid for the property plus improvements. And upon your death, the basis resets to the value on your date of death. So it steps up to that new basis value, which means that after your death, when your family goes to sell the real estate, the only capital gain that they pay is the difference between the date of death value and what they sell it for, as opposed to what you bought it for and what they sell it for. Now, what happens when somebody adds a child, or somebody other than a spouse, onto the title of the real estate as a joint owner is you're making a gift to them. And when you make a gift to someone, they take it at the original owner's basis, which means that they don't get the full step up in basis when you die. Instead, for at least half of that, if there's one other joint owner, they're going to pay capital gains tax on the difference between what you bought it for and what they sell it for. And that is a huge mistake in Colorado because, as we all know, our real estate has appreciated a lot. I have a lot of clients who have bought really lovely homes for maybe $40,000 and now they're worth $2 million. Or my favorite is I have had clients who bought property in the mountains or in Aspen, bought it vacant lots for $20,000, and you can imagine it's now worth $10, $12 million, right? That step up in basis is a big deal because we need to get rid of what they paid for it and get it stepped up to so that the value is the value on the date of death, so that when the family goes to sell the property, their capital gains tax is limited. It's just the difference between the date of death value and what they sell it for. And so when people add their family members onto the title of real estate to avoid probate, what they're usually not aware of is that they're going to wind up paying more money in capital gains taxes. And when you think about capital gains taxes, it's a good 20%-ish on the capital gain. That, especially if it's several $100,000 of gain, which it usually is at least, it's going to cost a lot more than a probate would have. Okay. And so one of those things I tell people to be very careful about is adding somebody onto the title of the house as a joint owner. As estate planning attorneys, we have lots of other tools, trusts, wills, beneficiary deeds that could still allow you to avoid probate, but give you the step up in basis too. And so you want to make sure that you take that into account. Okay. Now, that being said, if it is a married couple, typically we're going to want most of the assets to be held jointly because that way, if something happens to one person, it automatically transfers to the other one. And one of the concerns that I always have is that if one spouse dies, we want that transfer to be as quick and easy as possible. Because if you've lost your spouse, it's hard enough. You have enough on your plate to deal with. You don't need anything else. So we want to make sure that we use joint tenancy, we use beneficiary designations as part of our toolbox. And then on top of that, you need to have either your will or your trust. So what's the difference between a will and a trust? Well, a will is a document that you sign that says at your death, who's in charge and who inherits. Right? You also name the guardian for your kids there, but that's basically what it does. What most people don't understand, excuse me, is that when you have a will, your assets still go through probate on your date of death. So in the state of Colorado, your estate has to go through probate if, nope, I don't have it in there. Oh, wait, there it is. Your estate has to go through probate if on your date of death you have more than $86,000 in assets or any real estate in your name. So it's either or, okay? Now, what doesn't count toward that number? Anything that's held jointly, anything that names a beneficiary, right? But if you have assets in just your name, no beneficiaries, not held jointly, what happens at your death is that your will controls how those assets would be distributed. But the assets are basically stuck in your name. And so what happens is whoever you name as your personal representative, which is what we call the executor, the person who's in charge of your estate, has to submit to the probate court your will. And they do that along with a petition asking to be appointed as your personal representative. And that is the start of probate, okay? So what is probate? Probate is the legal process of retitling assets when someone dies. It has a really bad reputation, and it's not necessarily well earned. In some states, probate is horrible. In Colorado, it's really not that bad. I mean, I'm not saying it's fun. I've never had a client at the end say like, that was great, let's do it again. But it's not horrible. It's just a process, right? The reason that it has a bad reputation is that it takes time and money. So in Colorado, probate takes a minimum of 6 months. Really, it usually takes closer to 8 to 10 to 12 months, okay? And if they hire an attorney, which they don't have to, but if they hire an attorney to help them, average attorney's fees for a probate are usually someplace between $4,000 and $8,000. And that's if nobody fights, okay? So what happens then is that your personal representative, either themselves or they hire an attorney, they submit the will and the petition to the court asking to open the probate. And then the judge opens the probate estate and they issue a court order appointing the personal representative and giving them the authority to go and get access to the assets that are in the name of the deceased person. That's what it's all about. Because otherwise, you can't just walk into a bank and say, hey, this person died, I would like to have access to their bank account, right? You have to be on the account in order for them to give you that information or that money. So what the court order does is it allows you to get access to that account. And then the personal representative has to follow through with all these other steps that the probate court wants. So you have to publish a notice to creditors in the county paper. You have to do an inventory of all the assets. You have to keep an accounting. And you go through these steps. And as you do that, you make sure that you pay all the creditors, whether that's the final medical bills, the funeral bill, the visa bill, the utilities. And you have to file all the appropriate tax returns. So the final 1040 has to be filed. The estate itself may have to file a tax return. Once the bills and the taxes have been paid, then the beneficiaries get whatever is left. So at that point, you look at the will and you say, okay, the estate goes equally to these four people, to these four kids. So you split it up and you give everybody their share, and then you close the estate with the court and you're done. Okay. That in a nutshell is what probate is. It has this kind of abstract concept to it. People think, I don't really know what that means, but that's all it is. It's just a process with the court where you follow through the steps so that you can get access to the assets, pay the bills, file the taxes, and distribute what's left. Okay. If you have a will, the only difference between having a will and not having a will is that if you have a will, you get to say who's in charge and who inherits. If you don't have a will, then the statutes say who's in charge and who inherits. Either way, the question upon death as to whether or not you'll do a probate is not, do you have a will? The question is, do you have more than $86,000 in assets or any real estate in your name? And if the answer to either one of those questions is yes, then we have to do a probate. Okay. As I said, probate expenses in Colorado, not the end of the world, tend to be someplace between $4,000 to $8,000. Here's the rub. You have to do a probate in every state where you own real estate. And so if you have a house here and you have a house in Arizona, you get to do two probates, one here and one there. And in some states, the attorneys charge a percentage of the estate as a fee. And they tend to cost 2 to 3 times what it costs here. And timeshares count as deeded real estate, and so do oil and gas and mineral interests. So when I have a client who has a house here and they have a little lot in Kansas that they inherited from their great-grandmother that somebody's drilling oil on and they get $10 a quarter, and they have a timeshare in Hawaii, we're doing 3 probates. And now it starts to get really expensive, okay? Really expensive and really time consuming. And that's generally not what people like, right? Because it takes that time. All right, so that in a nutshell is probate. Now, I want to talk briefly about taxes. I know it's late at night and taxes are not the most exciting thing, but I want to talk a little bit about estate taxes because I think it will actually put your mind at ease a little bit. So the way that estate tax works, oh, this is weird. The way that estate tax works is that on your date of death, there is an exemption amount. There's an amount that you can transfer tax-free. If your estate is under that amount, your estate tax amount is 0. If it's over that, the overage is taxed at 40%. The current estate tax exemption amount is now $13.99 million. So if your estate is under that, you don't have to worry about estate taxes. Sometimes when I say this, people don't believe me because they had an experience with their parents or other family members where the family really got hit hard by estate taxes. And here's the thing, this number used to be a lot lower. And I don't mean a little bit lower, I mean a lot lower. Back in 1999, this amount was $675,000. And if you had anything over that, the overage was taxed at 45 to 51%. It was a big tax, okay? Now we've increased the exemption amount so much. And so now we're at $13.99 million. Anything over that is taxed at 40%. If you're under that, you don't even have to worry about it anymore. So as I always say, this is a really good problem to have, right? Here's the thing about estate taxes. They're kind of political, right? You may have noticed that. And so they change depending upon who's in charge of Congress. And that number is constantly going up and down and up and down and up and down. Currently, we're at $13.99 million. However, the law that we are currently under, the Tax Cuts and Jobs Act, sunsets at the end of this year. And that means that in 2026, the estate tax exemption amount goes down to what it was before this law ever passed. What that was $5 million. adjusted for inflation, so it should be around $7 million at that point. Will that actually happen? I don't know. Tomorrow, Congress could pass a law increasing the estate tax exemption amount, right? They could pass it next week. They could pass it next year. At any point, they could pass a law changing the estate tax. Given the results of the recent election, I tend to believe that we're going to have an increased estate tax exemption, right? But in 4 more years, it could go back down again. I don't know what will happen. People always ask me what will happen with the estate tax, and I wish I could tell you. I wish that Congress listened to me when I told them what things to do. I talk to my television all the time. They do not seem to listen to what I tell them to do. So what will happen with the estate tax? I don't know. But for right now, we're in a pretty good place. Most people aren't impacted by estate taxes. It's less than 0.5% of the population. Okay. So that's it about estate taxes. I won't talk about it anymore. All right. So when you die, right, your choices are to have either a will in place or a trust in place. As we said, with the will, your estate is going to go through the probate process. Not the end of the world, okay? But it's the process. If you don't want your estate to go through probate, then you do a revocable trust. A revocable trust is just a different approach to doing estate planning. So basically, the way that you can think about a revocable trust is it's just an agreement that you create with yourself, almost like a business, like an LLC or corporation. And you set up that business, you set up that agreement, and then you transfer all of your assets into the trust. So I always tell clients to, nope, I don't have that slide. I always tell clients to think about a trust like a box that holds your assets. Now, this is a really simple analogy, but I keep on using it because everybody understands it, right? You set up the box, you set up the trust, and then you transfer ownership of all of your assets into the trust. So you sign a deed, transferring your house from you to the trust. You retitle your brokerage account from you to the trust, right? The goal is to put everything into the trust. And what you're really doing when you set up a revocable trust is it's like you're doing the work of your own probate during your lifetime. You are transferring all of your assets out of your name so that when you die, you don't own any real estate. You don't own more than $86,000. It's all in your trust. Okay. Now, sometimes that sounds a little scary because you might be thinking, wait a second, that's my stuff. I want to be able to use it. Well, that's a nice thing about a revocable trust. With a revocable trust, you are still 100% in charge of all of the assets in the trust, and you can do whatever you want to with them. So anything that you can do with your assets now, you can still do with them in the name of the trust. So if you want to sell your house, you sell your house. You want to move your brokerage account to someplace else, that's fine. You want to pull all your money out and take a great vacation, do it. It's your money. There's no limitation on anything that you can do. So the person who is in charge of the trust is called the trustee, and the initial trustee is you. So basically, you put your assets in the trust, you just live your life like you always have. A good way to think about a revocable trust is like the IRS does. The IRS calls it a transparent entity, which means that as long as you're alive, they're going to pretend that the trust doesn't even exist. And pretty much so will everybody else, right? So you put your assets into the trust, and then you live your life, right? Use your assets however you choose. And then the trust works in different phases during your life, and it controls the assets both while you're alive, and then it says at your death who would inherit. And because the assets are coming out of the trust, we don't have to go through probate. Instead, the trustee just pays your final bills, files your final taxes, distributes your assets to who you choose, and that's it. So one of the reasons people use trusts is because it streamlines the process. They don't have to go through the probate process. It makes it that much easier for their loved ones, and because they don't have to go through all those extra steps. So does that mean that everyone should use a trust? No, right? We use trusts for some people, wills for some people. It just depends upon your preference. Reasons that I would recommend a trust for somebody instead of a will, if they really want to avoid probate. Some people have been through probate before and they had a bad experience. And so if they don't want their estate to go through probate, then you do a trust. Easy. If you have real estate in more than one state, it definitely makes sense to have a trust because you would take that little mineral interest in Kansas and put it into the trust. You would take your timeshare from Hawaii and put it into the trust. You take your house in Colorado, put it into the trust, and now you get to avoid probate in all those other states. So in the long run, it ends up costing a lot less money because you don't have to go through multiple probates. One of the other benefits of a trust is because you don't have to go through probate, it maintains some privacy for you. The probate records are open to the public. Now, the court clerks are pretty good about not just releasing information out to anybody. But bottom line is if they push that, they can get it. And that also means that your family members can get access to it, right? And there may be family members that you don't want to have access to it. Trust can be used to minimize or try to avoid challenges as well. So if you have somebody in your family you're disinheriting or somebody who's difficult or who you think might challenge your estate, you might do a trust instead of a will because it makes it harder for them to challenge. Not impossible, but harder. Okay. Trusts are great tools when you're planning for incapacity because when you set up your trust, excuse me, and you transfer ownership of all of your assets into the trust, you are the initial trustee, but then again, name a successor trustee. And if you become incapacitated, that successor trustee can just step right in and everything is already in the trust. And so they can just start managing it for your benefit right away. It makes it really easy. And it can be a good tool for complex planning. If we do have an estate tax situation, it's possible to use trusts to transfer double the estate tax exemption. So that allows you to transfer now up to about $27 million tax-free, right? So trust can be great in all of those situations, okay? So basically, you set up your trust, you transfer your assets into it, you live your life, hopefully healthy for a long time. If you become incapacitated, your successor trustee steps in, manages everything for you, and then upon your death, the trust is still in place. And the trustee steps in, they still have to pay your bills and file your taxes. You're never getting away from that. The IRS doesn't care if you're alive or dead. They want their money, right? But once they have paid the bills and filed the taxes, your trust document will say, well, then the estate is divided up amongst your 3 children, or 20% goes to this charity, and 15% goes to your friend, and 10% goes to your grandchild. Whatever it is, then they distribute those assets to the beneficiaries. One of the other benefits of having a trust is that you get to control how the beneficiaries get their money. So with a simple will, you're typically saying at the end of the probate, here you just get your money, do whatever you want to with it. You can go to Vegas, you can buy a Ferrari, whatever it is you're going to do. With a revocable trust, you could say, upon your death, you leave everything equally to your 2 children. Maybe they're minor children, and you want to put that money in trust for them. So you could say that money would be in trust. You name your sibling, their uncle, to be the trustee. They manage the assets for their benefit and use it to pay for their education and for their health care and their maintenance and support. But the trustee is the one that holds the purse strings so that that child can't just go wild with the money. And then usually you would say once that beneficiary reaches a certain age, then they would get the rest of their trust share, right? Wait until that they'd be mature enough to handle it. Or you split it up. You say you get half of it at 25 and half of it at 30, or in thirds. You get a third at 30, a third at 40, a third at 50. Depends on who the beneficiary is and how they manage money. So there's lots of ways to put money in trust for someone. And make no mistake, putting money in trust for someone is not a punishment. It's a gift. If you leave money to somebody and they are about to get divorced, and that money is not protected, that's a good thing. If you leave money to someone and they are not good with money, you put somebody else in charge of it until they are older, protects it for them, makes sure that it's used for what it should be. So this is a diagram of a joint revocable trust. So in this scenario, let's say that you have husband and wife, right? And they're both healthy and they clearly like each other a lot, and they decide to do their estate planning. So they go see their attorney, set up the trust, right? It's like a little box there in the middle of the page. They set up their trust and they transfer ownership of all of their assets into the trust, and then they just live their lives like they always have. Nothing really changes until he passes away. Now, they could have set it up so that all of the assets would just transfer seamlessly to the spouse. That's one of the huge benefits of a trust that people don't think about is you basically are doing all the work ahead of time so that if one of you passes away, everything is already done. It's already there. It's in trust for the spouse. It's just less that the spouse has to worry about. And then the spouse remains the trustee, unless she can't be the trustee, if she has incapacity. Maybe they've named somebody else to be the trustee, one of their kids, to step in and manage assets for her. But the assets are for her benefit for the rest of her life. And then at her death, then the assets go to their children. And they would have set it up ahead of time to say, maybe the assets go to Mary outright and free of trust. She's very mature, she's good with finances, so they just give it to her. But maybe Bob there isn't as good with money, and so they hold it in trust for him until he's 30 or something like that, right? Depends on who the beneficiaries are. So that gives you an example of how trusts work, right? This picture always cracks me up because he looks very angry. And so maybe you would want to hold money in trust for him. Maybe he's just waiting for his inheritance and he's not going to spend it wisely. This gives you an opportunity to say, we want you to use this money for X, Y, and Z. Use it for education. Use it to pay for a down payment on a house. It's a big deal in Colorado. A lot of younger kids can't afford to buy houses anymore. So you get to say how the assets are used. When you are trying to decide whether you should do a will or a trust, keep this in mind. Oftentimes, you can make the end result be the same, right? If everything is supposed to go equally to your children or all to your nieces and nephews, you can do that in a will, you can do that in a trust. The only difference is really the process for how the money gets there. When you do a will, they're going to go through probate. When you do a trust, there's no probate. When you do a will, it's less work for you. The work comes after your death. They do the work. When you do a trust, it's more work for you because you're going to do all the work ahead of time by putting the assets into the trust. It's less work for them after your death. When you do a will, it's less expensive now, more expensive after your death. A trust, more expensive now, less expensive after your death. It's just two sides of the coin, right? But there's not really a right or wrong. It's just what works best for you and your loved ones. That's really what it comes down to is which process do you feel more comfortable with to make sure that your estate is managed the way that you want it, because that's what it's all about. So when you think about your estate plan, right, it's not just about that death part. It's not just about the incapacity part. It's about making sure that you've covered all of that. And it's also about making sure that your beneficiary designations are set up correctly, that assets that are supposed to be joint are joint, assets that aren't supposed to be joint aren't joint. It's about making sure you talk to your family about your plan. And by this, I mean, if you do your planning, you definitely want to let your loved ones know that you've done it. And also, in an ideal world, where you've put it so that they can find it, right? And even better, leave them a list of your assets. Because in this day and age, one of the hardest parts is that people can't locate assets. They may not know where you bank. They may not know that you have an IRA or 401k through work, but you also had one that you set up yourself. They may not know that you have a life insurance policy. And if they don't know that you have a life insurance policy, believe me, the life insurance company is not going to call your family and offer to give them money. Someone has to know to call them. Okay. And so by leaving a list of your assets, I will tell you that is the number one thing that you can do to make your plan work efficiently and effectively. Leave them a list, because otherwise, if they don't know that you have an account at First Bank, they're never going to contact First Bank. And after a couple years of inactivity, that money will go to the state of Colorado. You don't want that. You want it to go to your loved ones. So give them a list of your assets. You've got to give them the keys to the kingdom. You don't have to do it now, but leave it with your documents so that they have a clue as to where to start. Because I can be really helpful, but I don't know where you bank. And I don't know if your life insurance policy is through Prudential or MetLife or somebody else. You have to leave them that information. And so an attorney can be a great resource for them to get them through the process once they figure that part out. But I'll tell you that the hardest part is when somebody comes into my office and let's say their parent has passed away and I say, okay, what are the assets? And they say, I don't know. I can't find anything. I can't find, there's no paperwork. There's nothing in the mail. They don't have the passwords for the computer. What do they do? Right? You have to leave them that information. So again, think about the fact that you're trying to make this as easy as possible for your loved ones. That's what it's all about. That's what it's all about. So I want to thank you all so much for attending. Nobody even fell asleep, which always makes me feel good. I hope that we gave you some good information today. I'm happy to stick around if you have any questions. Please just let me know. But otherwise, really, that's it. That's estate planning seems like this crazy, big thing, but it's just planning like anything else.
Beth, thank you so much. I appreciate that. There is a question in the chat.
Saw that.
Somebody's asking, what is the estimated cost of creating an estate plan?
I'd hate to be a lawyer and answer it like this, but I'm going to answer it like this a little bit and say it depends, right?
Okay.
It depends on if it's a single person, a married couple, if they're doing a will or a trust. So it can range anywhere from, $1,000 to many, many thousands. It really depends upon the situation. The way that we do it is I do a free initial consultation. And really, that meeting is just educational. And I literally outline an estate planning option for you. And if we're setting up a trust, what that looks like. If you're setting up a will, what that would look like for you and who the beneficiaries are. And then based on our conversation, I can quote you a fee in that meeting. Most estate planning attorneys work like that, but that's how we work. And if that's something that's of interest, that's something you could put on the evaluation. Not that you have to. Quite frankly, the way that I approach things is I don't care who you do your planning with. Well, I shouldn't say I should don't care who, but do your planning with a good estate planning attorney. Just get it done. It makes all the difference in the world.
Mm-hmm.
Al Potter asked if I could discuss ILETs. I'm happy to. So an ILET is an irrevocable life insurance trust. So that's a different type of trust than the revocable trust. A revocable trust, which we talked about today, is your foundation. When you set up an irrevocable life insurance trust, it's its own separate little entity that owns a life insurance policy. And the purpose of that policy is to pay estate taxes. So you set it up, you have the ILET owns the life insurance policy, and you gift money to the ILET to pay the premiums on that policy. And because it's set up like that, that life insurance is then not included in the value of your estate for estate tax purposes. And then typically you use those funds to pay any estate taxes that you might owe at your death. I will say, I think it's really important to review ILETs because I have a lot of clients who set them up back in the 90s or early 2000s when the estate tax exemption amount was $675,000 or $1 million. And they may look at the situation now and say, maybe I don't need this ILET anymore. And that's because the laws, change and the exemption amount goes up and down. So that's why it's always important to review your plan. I would say every 3 to 5 years or anytime there's a big change in the law to make sure that you're up to date.
Oh.
Any other questions? All right. Well, I want to thank you again. And thank you, Edith, so much for having me.
Yeah, thank you so very much. I really appreciate that, Beth. And I will get the evaluations out and over to you, hopefully in the not too distant future.
Sure. And what I'll just say about the evaluations is if you want to fill them in, that's great. If you don't, that's fine too. I appreciate any feedback that you have. So,
Okay. Thank you all. Everybody did stay awake. I will get the PowerPoint information to, or Ash will be posting that. Thank you all. And how about Lord's Prayer for us to end? Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done
on earth as it
as
is in
it is
heaven.
in heaven.
Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory, forever and ever. Amen.
Amen. All right. Well, good night, everybody.